Good morning, everybody, and welcome to our People Matter webinar this morning, specifically aimed at higher education institutions. My name's Pilly Fernandez-Mahoney. I'm a Principal Associate, and I will be joined this morning by my colleague, Patrick Gass. You should be able to see that. Hi, Patrick.
Morning.
So what are we going to cover today? Well, we're going to focus on two areas. Firstly, the Employment Rights Bill. So we're going to focus specifically there on unfair dismissal, 0 hours contracts, trade unions and industrial action. And then we're going to go on to discuss the new duty to prevent sexual harassment. So I'll hand over to Patrick to talk you through the Employment Rights Bill.
Thank you, Pilly. So as Pilly mentioned, we're going to take you on a very quick run through some key higher education focused, higher education relevant parts of the Employment Rights Bill, which it is safe to say is the biggest change to employment law that we've seen in a generation. We're not going to cover everything today. We're going to focus on specific elements that we consider are most relevant to you guys. However, the bill does cover a lot of other areas, but if you want more info, our colleagues Fiona and Samantha recently, I think on the 24th of October, also did a webinar, and they covered other topics such as fire and rehire and collective redundancy. And we will share a link of that recording with you if you want to have a look at that. And it's also available on our website. But turning to a quick overview of the bill, parts 1 and 2 are the ones that we're most concerned with. This covers the employment rights, and that's roughly 1/3 of the bill. Part 3 I won't go into today. That's pay and conditions, but mostly focused on the adult social care sector. Part 4, that is a large focus of what we're talking about today, trade unions and industrial action, and that's set out in 110 pages of legislation. But effectively what it is doing is repealing the Conservative government's trade union rules. Part 5 sets out a framework for the possibility of establishing a single enforcement body, something that successive governments have been keen on for a number of years now, so we'll see if that comes to fruition. And so in total, it comes to 149 pages. There are 28 employment law reforms contained in there, and it's safe to say that no area of employment rights and equality law is left untouched. So just moving on to a quick timetable. When can we expect to see the new law? Well, the bill had its second reading in the House of Commons on the 21st of October. It's now going to be scrutinised line by line. The government is very keen to seek input from all key stakeholders in this. So at the moment, there are 4 consultations that are out there, public consultations, so people can submit any views on the draft bill, and those consultations are closing in December, and we're expecting the Public Bill Committee to report on those on the 21st of January 2025. But then there will be other consultations launched next year as well. So we're not expecting anything to come in until the end of 2025 at the earliest, and some of the biggest measures such as unfair dismissal reform are not coming in before autumn 2026. So there is a big lead in time. The government recognises that there are some significant changes that we need to plan and prepare for. And I think unfair dismissal, I think this is probably the main headline from the bill and has certainly garnered the most press attention. It's part of the government's desire to give employees day one rights, and that includes in respect of unfair dismissal. So the 2-year qualifying period of continuous employment before an employee can bring an unfair dismissal is going to be abolished. So employees will, in theory, be able to bring a claim for unfair dismissal after 1 day of employment only. This is a big change, and I think despite what the government says, is going to lead to a lot more claims in the Employment Tribunal. And for those of you familiar with how the Employment Tribunal is working at the moment, it is already creaking. So we're gonna see more delays in the Employment Tribunal system, which is going to lead to more frustration for both employees and employers alike. Also going to lead, I think, to a focus on recruitment. It's going to be very important that you get your hiring decisions correct, because you haven't got that 2-year period, that effective statutory probationary period, to consider whether someone's a right fit for the business. But in respect to that, and recognising that, the government is planning a relaxed regime during what they're calling the statutory probationary period. It's an initial period of employment, and most commentators think that's going to be likely to be 9 months, where if you follow a simplified procedure, and your reason for dismissing relates to the employee, then there'll be a lighter touch process, a relaxed reasonableness test for dismissing people fairly in those circumstances. We haven't got a lot of detail of what that is at the moment. More detail is going to be published in regulations, and this is likely to be an area that's subject to significant consultation. So watch this space on there. But this is one of the biggest changes. Another plan here is reduced compensation for unfair dismissal under consideration, but I wonder whether that will survive the consultation period, because the reality is the average award for compensation of unfair dismissal isn't that high already. And just briefly, separate rules on automatic unfair dismissal that we already have, for example, whistleblowing, health and safety, TUPE, etc., they're going to remain. Another area that is relevant to higher education, the government is looking to end exploitative 0 hours contracts. And this, of course, is something that has been high on UCU's agenda for some time now. The wording of the draft bill is very, very complex, difficult to follow. But in short, if you employ someone on a 0 or a low hours contract, and there is as yet no definition of what a low hours contract is, if you employ them on those sort of contracts, they have the right to be offered a guaranteed hours contract reflecting the hours that they've regularly worked over a 12-week reference period. So they get offered a guaranteed hours contract if they work more than the 0 or low hours contract that they're on. They don't have to accept that contract, but you have to offer it to them, and that is a rolling right every 12 weeks. Of less relevant to the sector, there's also going to be a right to reasonable notice of shifts for shift workers, and also a right to a reasonable notice of cancellation or changes in those shifts. And if they don't get that reasonable notice, then there's going to be compensation available for late cancellation of those shifts. Again, we're waiting for regulations to put in the details. And again, I think this is something that's going to be subject to a lot of consultation and therefore change after that consultation, including on extending this right to agency workers, because I think there is a fear that employers will use agency workers to get around the rules on 0 hours workers. On to trade unions and industrial action. Essentially here, the Labour government is looking to go back 10 years to where we were 10 years ago. How are they looking to do that? Well, they're going to repeal in full the Trade Union Act 2016. This provided for restrictions on industrial action in terms of turnout at ballots, in terms of voting, and in terms of picketing, admin, etc. Most of the provisions of that act are going to be repealed, and repealed in its entirety is the Strikes Minimum Service Level Act. So this was an act, a framework which allowed the government to set minimum service levels requiring people to work even on strike days for essential public sector functions, including education, although there was always an argument that that didn't include higher education. Now, in practice, the minimum service level legislation has not been used, and the government is saying very strongly, please do not use this whilst we're consulting on its removal. So as I say, Labour is looking to reset the industrial relations. It's going to expand trade union rights, including providing access to the workplace and to staff for trade unions so they can undertake their activities in a more easy way. It's also going to make trade union recognition a lot easier. Now, that's not going to affect most of you guys because most universities already have recognised trade unions. And as I say, they're going to remove the minimum service levels as well. Essentially, it's going to be easier to get trade union recognition. It's going to be easier for unions to liaise with their staff on industrial matters. And it's going to be easier to take industrial action and undertake those activities. And staff will also get greater protection for undertaking those activities. Part of this is ballots for industrial action. The Conservative government brought in quite difficult restrictions for trade unions to comply with when thinking of taking industrial action. For example, a majority of union members currently must vote in favour. That's the majority of all union members. And at least 50% of the workers balloted must have voted, whether they turn up or not. That's going to be changed significantly. It's going to become a simple majority of those voting required, and no requirements at all for the level of turnout. That in itself is going to be a significant change, making it a lot easier for unions to take industrial action. And they're also looking to reduce the notice of industrial action down to 7 days from 14. Just very briefly, some other changes on industrial action. There's going to be some minor changes to the information required on ballot papers. For example, the type of industrial action that's proposed will be taken, whether it's strike action, action short of a strike. They're going to extend the mandate period. That is the length of the period after which a union would need to conduct a new ballot before taking the industrial action. Currently, that is 6 months. It's going to be extended to 12 months. Also going to relax the rules on picketing. For example, unions are no longer going to be required to appoint picket supervisors. As I've mentioned at the start, there is going to now be enhanced protection for staff taking industrial action. I think it's quite surprising how limited the protection is currently for staff. There is no protection where the detriment is short of dismissal. So that is going to be changed. There is now going to be new proposals protecting staff who take industrial action. They're going to be protected from suffering a detriment because of taking that action. And previously, at the moment, the protected period for against dismissal for taking industrial action is only 12 weeks after the industrial action. Now it's going to be extended for the entirety of the period of industrial action. So more protection. And just finally, other changes. Part of your Section 1 Statement of Terms and Conditions is now going to have to include a written statement to staff confirming their right to join a trade union. There's significant amendments being made to facilities and time off, essentially giving trade union reps, equality reps, the ability to take more time off to undertake their duties, and as I said before, more access to the workplace, to staff to be able to discuss trade union industrial action matters. So in short summary, unfortunately, the sector is likely to see emboldened trade union representatives trying to drive a harder bargain and more industrial action if agreement is not reached on key matters. Billy.
Thank you, Patrick. So I'm now going to talk to you this morning about the duty to prevent sexual harassment. So this is an amendment to the Equality Act. So we've got a new section in the Equality Act, and that's 40A. So sexual harassment means harassment of the kind already described in Section 26(2) of the Equality Act, which is unwanted conduct of a sexual nature. So this legislation was passed by the Conservative government in October 2023 to encourage employers to be more proactive in their efforts to reduce workplace sexual harassment. So what we're seeing is the bar being raised here. The preventative duty in force at the moment, so that's from the 26th of October 2024, only applies to sexual harassment, not to any other forms of harassment, but that's at the moment, and I'll touch upon that shortly. So the idea behind this was that there will be a duty to prevent sexual harassment rather than just a remedy for those who've suffered it. So the rationale is that having to bring a tribunal claim for harassment is not a pleasant experience. And it would be far better if that harassment hadn't happened in the first place. So it makes complete sense when you look at it that way. So as I've said, 26th of October, the law has already changed. You're now under this new legal duty to take reasonable steps to prevent sexual harassment of your workers in the course of their employment. Now, this is going to require positive and proactive steps, and I'll go through these. I'll just make an important point as well. So this is not a new cause of action. So this is a cause of action that will be added on to an existing harassment claim, and it's going to work in the same way as the ACAST uplift currently does for failure to follow a code on disciplinaries and grievances. Now, specifically for higher education institutions, I just want to touch upon Condition E6. So there's going to be a clear overlap with Condition E6, harassment and sexual misconduct. And as we know, the OFS considers progress to date by HEIs in relation to harassment and sexual misconduct to be patchy and slow, and this risks impacting on the student experience. So the OFS has believed that Condition E6 will make expectations really clear whilst allowing that flexibility, and it's going to set that real baseline for expectations. It's going to be clear to students and HEIs what can happen if they don't comply, and there are really serious consequences. So this is a really high risk regulatory area for HEIs, which crosses over both staff and student experience here. Now, E6 doesn't come into force until the 1st of August 2025, but that's not long to get your house in order. And let's just remember that the NDA ban is already in force, where the NDA covers allegations of harassment and sexual misconduct. So let's just for a moment remind ourselves of condition E6 so we can understand how the new duty fits in. So it's a condition of ongoing registration. It covers sexual misconduct and harassment. There's a number of very detailed requirements relating to policies and procedures, for example, relationships between staff and students, capacity and resources, and freedom of speech. HEIs are going to have to develop and publish a single document explaining your approach, and you must have the capacity and resources to be able to comply. So if you've put all that together, as well as the duty that's coming in October, there's going to be a key decision here as to whether you're going to have separate policies for students and employees on sexual harassment, and how are you going to deal with the overlaps if you do. So you're going to have to find that both staff and student sides are going to have to work together to ensure that all the requirements for E6 are met, and that policies, procedures and the approach that you're going to take works from a practical point of view, as well as complying with all your obligations and responsibilities under employment law. So there is a lot to be thinking about here. So I'm just going to go back to the duty to prevent sexual harassment. And again, as I've said, it's a positive legal duty. So this is going to require positive and proactive steps. It's about being anticipatory. It's about being proactive. It's not about waiting until a complaint has been raised to think about how to handle it. It's about anticipating the scenarios where that might happen so that you can stop your staff or prevent your staff from being subject to sexual harassment. And if harassment has taken place, then action has to be taken to stop it happening again. Again, this is proactive and this is an anticipatory duty. And that's something you really do need to bear in mind. So the Employment Rights Bill is actually going to further strengthen what we've got already. So at the moment, we have the standard of taking reasonable steps, as I've just mentioned, and that's brand new, October this year. The Employment Rights Bill is going to move that even further, and we're going to be talking about taking all reasonable steps. And this bill makes employers liable unless they can demonstrate that they took all reasonable steps to prevent the harassment. And also, this is going to extend it beyond sexual harassment, but to all types of harassment. What constitutes reasonable steps is, of course, not defined, and why would it be? But there is power to make regulations setting out what is reasonable. Now, the Employment Rights Bill extensions, these further protections, are going to come into force, we expect, in 2026. I've just moved on, sorry. So the Equality and Human Rights Commission have issued technical guidance, and it's really helpful. It runs to 75 pages, so it's not too long, but it does very much focus on helping employers to protect your workers and transform workplace culture. Now, it's not legally binding, but tribunals are likely to rely on it when looking at the scope of the legal duty, and also trying to understand whether you've met the standards that are expected. So the guidance is really useful to help employers and also lawyers to understand what is required by the new duty. So in that guidance, there is an 8-step guide, and it is really helpful. Now, this is not exhaustive, but these are the kinds of things that you're going to be expected to be thinking about. So this is about that baseline of developing an effective anti-harassment policy. It's engaging staff in putting this together. It's assessing and taking steps to reduce the risk in your workplace. So specifically your workplace. It's about reporting. It's about training and adequate training. It's about knowing what you're going to do when a harassment complaint is made, however that complaint might come in. And it's also about dealing with harassment that might happen by third parties as well. And importantly, and I can't stress this enough, it's about monitoring and evaluating those actions that you've taken. Implementing the steps that are set out in this 8-step guide should help you take that positive action which is required to prevent and deal with sexual harassment in the workplace. It's not a static duty, as I said before, and the guidance makes that really clear. You have to keep reviewing the steps that you're going to take to meet the duty on a regular basis, and in light of your assessment of the risks that are faced. So again, it's about not just putting these things in, but making sure that you're checking that they are working, And of course, new issues might arise, which also you need to think about whether those are anticipated or not, and you might need to change the way you deal with certain things depending on how this develops. So, yeah, the million-dollar question, what might reasonable steps require? Now, we set a few of these out on the slide. But the first one, to be honest, is recognising the extent of the problem. It's a really important first step, because you can only prevent harassment if you have a clear view of where and how it is occurring in your institution. So you need to carry out a survey, for example, to measure attitudes. Is this a major problem? Where is this a major problem? Those are the kind of things that you need to be thinking about so that you can go through the other steps and know what training is required and where that training is required to be focused. And you also need to think about what needs to be in my policies and procedures, what needs to be in the way that I want these things reported, so that you can understand how to comply with all your obligations under the duty. Now, carrying out risk assessments is something, again, that we would suggest that you do. Now, you can take a similar approach here to health and safety risk assessments. So, you're taking that formal and structured approach, but applying that to sexual harassment in the workplace. Again, remembering that we're also thinking about third-party harassment as well. Some sort of survey about the prevalence of sexual harassment, again, will be really helpful, because this is all about identifying risks. And you'll actually have quite a bit of information already, which might be able to help you go some way to make sure you comply, because you're already going to have past complaints, you're going to have exit interviews, you're going to have absences, which may or may not be caused by instances of harassment. So you've already got some information that you can start from already to help you make sure that everything that you're putting in place is going to deal with the issues that are anticipated. Of course, having a reporting system in place, really important. You might want to consider different ways of reporting sexual harassment, because different employees will have different preferences for that. Some will prefer to speak to someone who can provide them support and guidance in person. Other staff might only be willing to report things online anonymously without having to talk to someone. You need to publicise the different methods that you've got available, and you might want to consider using new tech and AI, for example, to identify any patterns. And this is remembering that trust will be gained by transparency here, especially when it comes to reporting. Staff want to be able to see reports being taken seriously and actually being acted upon. And let's not forget about training. I mean, there's been a recent ET case that has just reminded us that a tick box exercise for training, where that training is stale or it's old or it's no longer relevant, is just simply not going to do the job. Training needs to be periodic, it needs to be refreshed regularly. Training needs to be designed for specific institutions and for different audiences. Senior leadership, for example, might require different training to those for managers and then to staff as well. So those are the kind of things you need to be thinking about. So what happens if we get this wrong? So what are the legal duties the legal consequences if the duty is breached? So the Equality and Human Rights Commission can investigate employers who appear not to be complying with the duty, and they can ultimately issue an unlawful act notice if you continue to be in breach. So if you don't comply with an unlawful act notice, you can be fined. It's worth saying that unlawful act notices are rare, but that's at the moment. We're aware of one from Pontins in February 2024, where it was found that there was multiple instances of race discrimination against Irish travellers at a holiday park. But the real impact here, to be honest, of this new law is going to be felt in the employment tribunals. Because if you as an employer can't show that you've taken reasonable steps to prevent the harassment in the first place, then the reasonable steps defence fails and you'll be in breach of the new duty, and the tribunal may increase compensation awarded to the employee by as much as 25%. So if an institution loses a case, it's going to cost more. And the Equality and Human Rights Commission have set out a really helpful example. So they've talked about, so for example, if you've got a worker who's successful in a claim for sexual harassment against their employer, the Employment Tribunal orders the employer to pay £30,000 compensation, for example, for loss of earnings and injury to feelings. The tribunal then needs to then consider whether the employer has breached the preventative duty, and if so, whether to apply a compensation uplift. So they're going to look for evidence to see whether that institution has actually looked to prevent the instance of sexual harassment in the first place. And that's where you're going to have to show, well, we've done this training, we have this policy, we have these reporting processes. You're going to have to show that you've carried out risk assessments to make sure that you have prevented, well, at least tried to prevent as much as you could the instance of sexual harassment. So, for example, if the tribunal decides that the institution has breached the preventative duty, but the extent of the actual breach is limited, for example, the employer has anti-harassment policies and procedures already, these were communicated to staff through regular training. However, the tribunal thinks, well, that's okay. They might have done that. They might have ticked the box for policies and procedures. Those were communicated to staff. There was regular training. However, what the employer didn't do is review the effectiveness of its policies and procedures and training. They didn't do that over a number of years. What the tribunal might then do is go, well, you haven't quite hit the bar that we're expecting you to hit. And therefore, because of that, you haven't been reviewing the effectiveness of those policies. You've just put them in, you've done the training, and you've left it at that. A tribunal may consider awarding, for example, only 10% of the allocated 25% uplift. And therefore, the total compensation that the institution must pay moves to £33,000. So that shows you how a tribunal will look and work through that preventative duty.
Thank you, Pilly. So, as mentioned at the start, unfortunately, we do not have any time for questions today. But if you do have any burning questions about this or indeed any other topic, do feel free to drop us a line. Our contact details are on the slide. And as Pilly mentioned, the slides will be shared with you after this webinar. So thank you very much for your time this morning, all.
Thank you.